Tanya, am I audible?
Yes, sir, you're audible. Sir, with your permission, may I start the session?
Yes, yes, absolutely.
Thank you so much, sir. Argumentative skills are fundamental to practice of law. They enable advocates to present their client's case persuasively, navigate the complexities of the legal system, and contribute to achieving favorable outcomes in legal matters, whether through written advocacy in legal briefs or oral advocacy in courtrooms. These skills are essential for the effective practice of law and pursuit of justice. A very warm good morning to one and all present here. I, Dania Roshan, on behalf of RSLW, welcomes you all to the fifth session of the second National Moot Court Training Workshop organized by Rajasthan School of Law for Women, Jaipur. Moot Court is a valuable component of legal education that hones students' research, writing, and oral advocacy skills. It requires thorough preparation, effective teamwork, persuasive argumentation, and professionalism. By mastering these fundamentals, law students can excel in moot court competitions and develop critical skills for their legal career. Today we have with us Mr. Aditya Bora, sir. Sir is a senior associate at Vedanta Law Chamber, experienced associate with a demonstrated history of working in the law practice industry, skilled in research, civil and criminal laws, including arbitration, insolvency, and MSMEs. Strong professional, graduated from Nirva University Institute of Law and postgraduated in human rights from University of Rajasthan. Sir has various papers published in his name in prestigious journals of the globe. Sir also holds an advanced diploma in drafting, negotiation, and enforcement of contracts from National Academy of Legal Studies and Research, University of Hyderabad. Sir was also a guest speaker at the RSLW National Moot Court Trading Workshop 2021. We are honored to welcome you, sir, to the second edition of the workshop. Before beginning the session, there are some guidelines for the participants. Firstly, keep your videos off and audios on mute during the session. Secondly, the session end of this at the end of the session, a feedback form link will be dropped in the chat box, which has to be filled to receive the participation certificate. Thirdly, in case of any misconduct, the participants can be disqualified from the workshop. Thank you. Now I request Mr. Aditya Bora sir to commence this session. Over to you, sir.
Thank you so much, Dania. Good morning, everyone. Good morning, Vatika ma'am. Thank you so much for having me over this
Good
workshop.
morning, Aditya.
Good morning,
Thank
ma'am.
you for
Thank you so
accepting our invitation once again. It is always wonderful to have you here.
ma'am. It is always a pleasure for me to always be a part of such event. Thank you so much. So I have been given one of the most important tasks, which is there in the moot court, which is the argumentation skills. Uh, Before we move on with what argumentation skills are, I just want to bring it to all of your knowledge that there is one thing which you need to do while you are there at the argumentation part. By now, it is expected argumentation starts and you are there at the moot court hall. So by this time, your months of hard work which you have done, your effortless nights and everything which you have done is on a pen and paper. And now you are there to present your paper before the judges. So now we are going to start with how to present your paper, what you have been doing right now, and how to effectively put it to the knowledge of the judge who is there, and how to get favorable results. First of all, like as I've been informed that we'll be having another session also on the court mannerism and etiquettes. So therefore, arguments and etiquettes go hand in hand. So I request all the participants to pay special attention to both these sessions because argumentation is always followed by what is courtroom mannerism and courtroom etiquettes. So only one thing which I want to point out at this point is the dressing, the way you all dress in a moot court competition, be it a boy or a girl. So please pay special attention to your dressing. It should be neat, it should be tidy, and it should be presentable. That is the first and foremost thing, which comes to the knowledge of anyone who is standing out. So just keep a special just keep a special thing of that. Now the next is you are there before the judge. You have the memorial in your hand. Before going to the arguments, there are a few points which I need to tell you. Just have a mentor with you. A mentor is the one to whom you can approach day in and day night. You can just simply go to the mentor and just practice and practice what all you are going to argue before the judge. And generally, the moot court teams consist of three members, wherein two are the mooters and one is the researcher. So it is always advisable that whenever you are choosing that who two would be the mooters, you always have drilling sessions among yourself and to be and being very practical. Just decide whoever your mooters are, who can basically uh, be effective at the mooting. And this process has to be very analytical and it has to be very practical. It should not be that okay, since you are my friend or you are my colleague, you do the mooting, I'll be the researcher. No, it has to be very, very practical that who is good at researching, who is good at mooting, and who is the one who can, pass on the chits to you wherever the mooter is facing a difficulty before the judge. He's unable to answer the query of the judge. So it is very important to analyze and to determine who will be the mooter and specifically who will be the mooter number one and mooter number two, because mooter number one is as good as an opening batsman of any cricket inning. He sets the tempo of the entire innings. So once your tempo initially goes wrong, it would be a bit difficult for you to catch up again. So the first and foremost, determine who shall be the mooter and who shall be the mooter number one and the mooter number two. That is the first and foremost thing. Also, by this time, each one of you, like the mooter number two, and the researchers should be so thorough with the memorial. Like they should know exactly word by word where what is written where. You should be so thorough that even you are ready to argue your case, you are ready to put your arguments without even looking at your memorials. So that is what is expected out of the mooters at this point. Because a lot of time it happens that the judges, in order to check how the mooters are, what is their preparation, they generally ask the mooters to keep aside their respective memorials and to say that okay, now you argue what your case effectively is. You people all know that what how the research is being done, what to draft, where to draft, what are the contents of a memorial, how everything are placed. But argument is not to speak everything. There is a difference between giving a lecture, there is a difference between giving a speech, and there is a difference between arguments. Now, as the word comes arguments, it is not literally to argue. It is basically to plead before the court. And moot court is in a way a court only. Pleading means, in literal words, mangna. You are seeking something from the judges. So if you are seeking something, your approach has to be humble. One should not be too arrogant. Your tone should be not too arrogant, so that you're just coming out and I'm there for arguments. No, it should not be the case. One should be a little humble, one should be a little submissive, and you should be persuasive. So that is how your tempo should be. There are a few things which you can do so that you can gain confidence. Some people generally what they do is that they keep a pencil in their hand and they just tickle their pencil. That is very annoying. So keeping a pencil, tickling a pen, I would suggest that these things should be avoided. These should not be done. At the most, what you can do is generally you are given a wooden podium where you just stand and you argue your case. So all you can do is you can just hold that podium, because holding a podium, it is always considered that it would give you some confidence before to just argue your case. So these are the few things. Now what you have done is you have come before the court. You all three, the team is respectively being seated by the court master. So now what happens is the mooter number one stands up, and you have to seek permission for each and everything. You have to seek permission. You have to plead that first of all to approach the dais. Now what you can say is, if it please this honorable court, the counsel on behalf of the appellant or respondent seeks permission of this honorable court to approach the dais. Then you, and whenever you are being answered, you always have to say much obliged and I'm grateful, because for each and everything you have to say these things because you are basically there to plead. So this is one thing you always have to just get into yourself. You have to put these things in yourself, that I have to plead one thing. So now you are there to the approach, then you have to, then since you are there, so the first thing is that you how to bleed. So you'll say, if it with the permission of this honorable council, the council would like to to seek permission of this honorable court to address your lordship as your lordship or your honor, whatever it. So if there is a female judge also in the quorum, then you can say your ladyship as your lordships, because collectively you have to address this court or the podium. So once you are given the permission that okay, proceed, then again you have to say much obliged, and then you have to proceed. So in an all, you have to be very submissive. You have to seek permission for each and everything, and you have to be confident. The confidence comes not only, it is not a matter of time. It is not, it just doesn't come overnight. The confidence comes when you are through with your memorial. It shows that okay, now I am ready to argue this case. I am so thorough. I have confidence over what I have, the hard work I have done, the months of efforts which I have done. So that is the confidence that should come from your face. So now you are there. Now there are two mooters. So it is the responsibility of mooter number one, that how you have to articulate your arguments and what is the division of your arguments basically. You have to say that there are in and all 3 to 4 arguments which are there, in which the mooter number one shall be dealing with the arguments number 1 and 2, and mooter number two shall be dealing with arguments number 2 or 3 or whatever, and the prayer. So this is how the bifurcation is to be done, and you have to put it to the knowledge of the court that okay, this is the argument, and this is the division of work that we have done, and this is the manner in which we will be pleading this case. So that is one thing. Now what you have to do is you start your arguments, and the process goes on. Before that, we'll also cover a few things which we say the nitty-gritties of the arguments, which are some basic aspects. First is, don't use your hands too much. Like some people have their habits to just do their hands like this and that. Okay, my lords in this case and this and that. No, that is not required in a way. Simple moving of hands is still okay, but still to the most extent you can, just don't wave your hands like a lot, because it doesn't look good. And to be quiet, to be calm, and to be composed is one thing which is always anticipated, and it also shows that you are very thorough with your memorial, and you know, and you are well prepared before this honorable court, which also in a way pleases the court, which says that okay, if someone has appeared to plead before us, he is well prepared. So the court also has a confidence over this man, that okay, all right, this man considers us something, and he's there. That is one thing. Also, while you are practicing the arguments which are doing, always try to anticipate the questions. Always anticipate the questions, because the more and more you anticipate, you try to anticipate that okay, how far a judge can stretch. So that is the practice you need to do, because that is what will help you as far as your grilling is concerned. So that is one thing. Have a complete insight of your memorial. That will help you in arguing. You'll not pause. You'll simply go on and anticipate the questions to the most you can. Try and argue in your practice sessions before someone who is completely alien to your mood problems and your memorials. Because the point is, if you are able to convince a person who just doesn't know anything, then half of your job is done, which means that you are so thorough and you are so confident that you can make a person understand who was completely alien to your question. And that is the confidence that would boost your confidence to another level. So that is one thing. Now, as we already talked about, you have to maintain your tone. You have to be very respectful for the judges, and when you are being grilled, because the point is that you will be grilled to another level. That is why moot courts are, because it has to, like, it is meant to test your patience, your research skills, and your temperament, where arguments comes to the picture. So you just don't have to get perturbed. That is the only thing which is there. You just don't have to be perturbed. You have to stand still. You have to be quiet, you have to be composed, as well as you have to answer the queries to the judges. And if you are unable to answer any of the query, you simply have to say the council seeks ignorance. And they, if even if after that also, if the judge is unable, like he's not sparing you, then you can say the council seeks ignorance, and the councils would get back to the honorable judge uh, after due research of the query. This is the for first and foremost thing which a council should understand and he should always do. Now, while you are starting with your arguments, it is always advisable that carry a small piece of paper. Now, what that paper would be, that would only have 6 to 7 points, brief and wider points, and these points would basically help you to understand and to remember what is the arguments that you have to do. It will be an outline, and this outline has to be always there with you. And since it would be prepared by your own hands, so you would remember it better. One. And this outline should not only be of your own arguments, but you should also try and make the outlines of the arguments of your co-mooter as well. Because at times it happens that your co-mooter has basically left something to say, which was an important factor, maybe of a number of reasons. This could be because of the grilling and the time got completed, or of any other reason he got nervous or something. So the point is that if something important which was there, which basically was a trump card to say, so then also you should be so understandable, you should be so handy that you should just simply come and you should argue that before the honorable court again. Now, when we come to the next, just understand one thing: you are not there to give a speech, because the point is, a lot of time it happens that the motor simply come, they simply open their memorials and just simply start reading it. That is not a speech. You are not there for pitching what is what is their important points. Pitching and everything is not at all required. The only thing which you need to do is to come and to plead. So that is the only thing you need to understand. And I'm giving a lot of emphasis on this particular aspect because a lot of times when we generally go to judge the moot, what happens is that mooters are generally there to give a speech. Like the way they are arguing, it appears as if they are giving a speech because they are simply either reading their memorials or they are citing something uh, which is there, and it is apparent that they are just simply reading their memorials, which is not generally advisable. You should be so thorough that you should just start simply giving your arguments, and it should not be a speech. One. Also, while you are given a problem, you have to prepare memorials on both the sides, petitioner side as well as the respondent side. And it generally appears that it always ends up saying that one side is weak, one side is strong. So let's just hope that we end up in the draws to be on the applicant side or the respondent side, or whichever way that is. First of all, keep these things aside, because if you have started off on this note, then your confidence is going to shaken like anything. A mood problem, whenever it is made, it is so deliberately made that it is not that either of the side is weak. It appears to be weak for one of the sides of like one of the parties, but it is generally not. And there is always a scope to argue this matter from both the sides on equal footings. So that is one thing. You just need not have that psychological barrier with you that okay, this side was weaker, we couldn't have performed better. No, that is not the case. Just have confidence on your memorial, just have confidence on what the research you have done, and confidence over your argumentative skills, and just try to pursue to the best you can. Because if you think that all these things are there, so obviously you'll have a leverage also. If you see a running track, so there are 4 to 5 lanes which is there. So the person who is standing on the first lane, it appears that he is running slow because he has a smaller track to cover, but no, he is standing at the back also. So it is always aimed to make all the participants at par, and it would not it would not be correct to say that one side was stronger, one side was weak. No, that is just a psychological barrier. And have confidence. One. Secondly, be mentally prepared for grilling to the next level. Mood courts are generally meant to test the patience of the mooters, as well as what is the temperament of the team as a whole, as to how a team or a team member generally baffles, how the other team, just simply comes up to his rescue, how the researcher takes charge. So the point is, you have to be so mentally prepared for the grilling that would be there by the judges. Because if you are mentally prepared, you'll stay calm. You should understand that mooting and going before a judge would not be a cakewalk. If it was, then simply you were lucky. So the point is, if you are being grilled, first and foremost, you should be thankful that all right, your memorial was considered and you had an active participation from the judges as well as and it was an active participation from your end also. So that is one thing. You should always be prepared of what the grilling would be, and it should be like whenever you are practicing also, like I would suggest that you should give at least 20 to 25 sessions of practice, like for your arguments before appearing into the actual booths, because this is as good as net practice, what you do. So this practice would help you in anticipating questions, like what questions would generally appear from the court, how the judges could be, and in a way, it would help you uh, in every sense. Secondly, you should know what your strong and what your weak points are. Supposedly, like there is like the fact sheet which is given to you, you can analyze that okay, this point can come in our favor. This has to be relied very heavily, and there are some points which you can say that okay, it would be better if we just bypass these facts because this might go against us and we might be grilled on that. So while you are simply going through your facts again and again, your arguments again and again, what your research, what the authorities that you are citing, if you are just going through all of these things, so it will be really helpful for you to anticipate and to perform better. And you should be very thorough with what your strong and weak points are. Once you are able to analyze that what your strong points are, simply harp upon those points, try to give emphasis on that points. If possible, you can plead those points a couple of times as well, because you can simply do that. And if your weak points are, you can simply try to avoid that. Okay, these are the points we just don't want to get onto that page. If the questions are asked from the judges, or something happens that we have to travel to that tangent, then okay, we are prepared, but we don't want to go there unnecessarily. So that is the approach which you can generally follow. You have to keep your strong and weak points ready and handy. And not only you, your co-mooters point, as well as it is the responsibility of the researcher to be prepared as to what all points they can anticipate, what all points are coming, and what all points could be there. Because what happens is that once the mooter is engaged with the dialogue with the judges, generally it happens that their mind, is just baffled because of the continuous grilling which is there. But it is the mooter and the co and the co the researcher and the co-mooter which is sitting. So they have an opportunity, to simply pass the chits so that they can supplement their arguments, and they can make the mooter at composer who is there at the who is arguing. So that is one thing. You should always keep your strong and weak points ready, handy, and you should be ready to harp upon. That is one thing. Now, at times, what happens is that you are so continuously being grilled that you don't know what is the way out, from where to go, and the time is also constantly running. So that is the point that where you should know how where to steer up. आपको गली कहाँ से निकालनी है? This is the one thing you should very well know, and this can come only and only when you practice, practice, and practice. of your moot memorials in your arguments before the actual moot court competition. Because if you are continuously practicing, you know that what all questions can come, even if not 100% of questions, at least you are able to anticipate what 60% of the questions might be there. So you are able to stir up the questions with a very submissive and a respectful tone, and the conversation going as such, and you are staring to the court. Even the judges know that okay, you are trying to staring up, which means that okay, this man has a presence of mind. You are acting smart, and that is what is actually required. Because in a particular moot court competition, not there is no side that wins. It is a competition. So competition is the showcasing of skills and the showcasing of what all research and everything, and like what all hard work you have done it on paper, and that should show from your arguments. And not everything has to be argued. You should be so categorical, and you should be able to steer up, and you should just be able to sail through, so that you are there on time and you are able to complete the proceedings on time. That is one thing. Now, when a judge asks you a question, as if you are arguing, you are in a flow, and a question is being asked, and you are taken aback. Okay, you couldn't understand what the question was. Don't answer in haste. Take a pause, second or so. Just think. Just try to think. Take a pause, and then try to answer what is being asked. It shows a psychological sign to the judge also that okay, the mooter who is there, he is thinking upon your question. He is not giving this answer in haste. It's not that he is not bothered of what is being asked. He is thinking, he is analyzing, and then he is giving the answers. Because there are a lot of criteria on which the marking is done, which is what was the approach. Subsequently, it is there that how did you answer the questions? How did you understand the question? And if you are unable to understand the question on the first instance, don't hesitate to ask the question again. You can simply say, if my lords may pardon my lords, if the question can be repeated again. Or you can simply say, sorry, my lords, can you please repeat the question? In a very humble way, you can ask the question again. Even you can ask the question twice. And there are high chances that if the question which was being asked, it was asked in a very complex manner, probably the judge would himself, simplify it for you. Because if he has asked you something, he would expect that all right, he's expecting an answer, so he would simplify the question for you again. So if the question is being simplified, and while you are asking the question either once or twice again, you have those 5 seconds with you. You have to be on toes. Even the researcher and the co-mooters have to be on toes. You have about 5 seconds for you, and answer that question again. And if you are unable to answer, just try to steer through the conversation so that it doesn't get worse. So that is how you should have an approach toward the questions and answers that are being put up to you by the judge. So next is, like in your previous sessions, you would have been taught that how to keep a compendium ready. Now, compendium is something which is extra from your memorial. These are the authorities which you are actually citing. These includes your bare acts or any of the journal, the copy of journal on which holds the value of any authority or something, or you have the cases, the case laws and all those things with you. So now what happens is there is a complete compendium. Keep the compendium handy with the flagging. It shows that you are well prepared with all your compendiums, and subsequently it shows that you know you are there with an authority. Your memorial is just not in the air. This is a well researched memorial, and the reliance would be placed on the authorities whenever it is asked. So now, like whenever you are arguing, just place your reliance on the authorities also, and you can simply supply a copy of the compendium, like you are if you are arguing, So simply by arguing, you can say that, all right, this is the memorial and we are placing reliance on this particular case, which is placed at place number so and so, and this is flag number so and so. So it is really convenient for the judges. And even if the judge is unable to read that complete portion, it simply shows that, all right, the mooter is at least well prepared, and this is a well researched proposition which is there before the judge, and he's left with no other alternative but to award you additional marks for it. So that is one thing which would there, and plus this also shows confidence also. So that is one thing which you have to understand, and which you have to do. This is an additional work, but there's always pays on. Next, if you have misstated anything that there was a misstatement by you, or if something which was which was not warranted but still you have done, which we categorize as a mistake, a bona fide mistake which has been done. So any mistake which is being done, so what you can simply do is that you can simply say, I apologize. The council seeks apologies of this honorable court, and you can simply move forward. There is no point in defending of what you have done and unnecessarily getting into quarrels with the judges. It is not at all advisable. You have to keep into mind the actual intent of pleading, and not in literal sense arguing before the court. So once you are there before the court, your intent is to plead your case. You have to seek the relief which you are seeking from the, like, which is there in your memorial. So what you have to do is, you simply just cannot go and defending your mistake, that this is something I misstated and now I'm defending it. No, it would simply waste your time, and that would result in less marks. No, simply say, the council seeks apologies, and you are through to it. Now, these were the basic points which we basically keep in mind while arguing the case. Always try to participate in the intra-memorial moot court competitions which are organized by your college, so that you are prepared for the national moot court competitions which are there. Always try to have a word with the people around, and just try to be updated as much as possible. Because what happens is, while at the time when your memorial was prepared, at that particular point, it was a month ago. Now a lot of things could have happened in the next month. Like, this is the time between the submission of your memorials and the actual date of your moot court competition. But if you incorporate those things in your arguments, even if it is not there in your arguments, if it is not there in your memorial also, then it would add to your benefit. So that is one thing. Always be so updated, and especially the problems which you are dealing with, because generally the mood problems are arising from the recent developments that are taking place. Either it is from a recent case which has simply happened, or any particular debate which is going on, any legal subject which is there. So it is arising out of something which is there in your vicinity. So, and as a law student, it is always advisable that be so updated that you are you are always comfortable, and you are just simply able to deliver. Now, coming to the memorial part, you simply don't have to start with the arguments and arguments advance. No, you are there. You sought permission from the judges. You have been giving the permission. You have set a tempo for your arguments. Even if you are the respondent, also, then also you have to do all these things very precisely, and you have to, like, deliberately, these things have to be done. So now when you are there before the court, if you are from the appellant side, the first and foremost thing that you have to do is you have to satisfy this court with the jurisdiction. It always appears that jurisdiction is what is a cake. Since it was there in the problem, then the jurisdiction is there. No, it is not. You have to satisfy the court that this court has the jurisdiction to admit, to hear, and to finally adjudicate these issues. And it is only after that you can simply move forward. So always first try to satisfy the court with the jurisdiction that they are vested, and they are, that they are competent to hear this particular case. Because generally what will happen is that if you don't simply cover up the jurisdiction and you start with your arguments, the court might end up asking you that what is the jurisdiction that we have. So it is your responsibility to satisfy the court with the jurisdiction. At the most, what would happen is that you are pleading before the court that this honorable court has the jurisdiction to hear this case, and the court would say that all right, we assume the jurisdiction, you proceed. So that is fine. That is an advantage for you, but you simply cannot deem that this court has its jurisdiction and you simply start off with the arguments. No, that is not the case. Subsequently, when you start with the jurisdiction, you are done with the jurisdiction. The next part comes is the facts of the case. Everybody in the courtroom is aware of the facts. Still, you have to plead your facts before the court, and not entire fact has to be narrated again. No, you don't have to twist your facts, but you have to put your facts in such a clever manner that it appears that the problem belongs to you, and you are going to sweep away this particular event in your favor. That is the approach with which you have to simply go. So now what you have to do is that whenever you are there, whenever the facts are being pleaded, you simply have to go and you have to narrate the facts. You seek permission of the court first, that the counsel would like to narrate the facts before this honorable court. If the court says that no, we are aware of the facts, it's fine. Then you simply have to move ahead. It's an advantage for you. But if not, then you should be so thorough with your version of your facts that even you should not even be looking at the memorial for a second also. And if you are being asked that, okay, just close your memorial, then also you are ready to plead your facts before the court. Because facts are the most important thing which you should understand. And I hope you would have been taught in your previous sessions also. I would re-emphasize that you should be so thorough with your facts. Even a comma and a full stop where it was used in the fact sheet should be on your tips. And just don't be in the impression that I have read the problem once and I'm thorough with it. No. While you are reading the problem for sixth or the seventh time, you would always have another angle to that. That is how the mood problems are generally drafted. So just don't be in the impression that for the first time you read the problem and you are thorough with that. That is not the case. You always have to read the problem again and again and again. And even I would advise that once your memorial is also finalized, you have submitted your memorials, then also read the problem again and again. Because a lot of things can be covered up in your arguments if something has been left in your memorial also. That is the last nail which is to be, which is to be there. So always keep the facts ready on your tips because that is the key to your performance in the moot court. One. So you have pleaded your facts before the court. So now once the facts are there, then you have to come with your arguments. That all right, these are the issues. This like the issues which we have framed. If you are being asked that why are these issues framed, then you should understand what is the purpose of each and everything. Because if you don't know the purpose, like let us just go back again. While we are on the jurisdiction, if you understand one thing, why we have to emphasize on the jurisdiction, the point is if you are on the respondent side and if you are able to convince the court that you don't have any jurisdiction, the case simply comes to your way. You don't have to plead your facts also. And it generally happens also because if a court which is not competent to hear anything, then nothing actually remains. So what happens is that you have to understand what is the intent of each and everything which is there. So jurisdiction it is there, facts it is there, and then you come with the issues. Now the issue is what is the point which has to be decided by the court. I'll just give you an example. For example, a person borrowed some money from the other person, and he says that all right, he files a suit for recovery, or let us say any example of what is a violation of human rights. Any moot problem comes on the violation of human rights. So the point which is there before the court is that is there any actual violation of human rights? What do we have to decide? Like what were the rights first, which were violated, by whom? So these are the issue which has to be answered by the court. So if you understand that what is the intention behind drafting the issues, then you would be able to draft those issues better and you will be able to plead those issues better before the court. In your arguments. So just understand the intent of what you are writing. Then you will be able to plead those issues better. And even I would advise that once your memorial is finalized, you have submitted your memorials, then also you are ready to plead your facts before the court. the intent of different sections of your memorial. So when you are done with your issues, then you come with the arguments. Arguments at the initial level, you should be able to convey before, like convey to the court that these are the 2 to 3 arguments or 4 arguments, the major arguments which are there, wherein one or two would be dealt by me and by the next by my co-counsel. This is what gives a brief bifurcation to the judges that all right, who would be there and who would be dealing a particular issue, and where we have to stop and what is to be asked by whom. When you bifurcate your things, half of the job is done. So it is very important that you clearly convey that who would be dealing what. One. But this does not deal that you are not aware of what the other person is actually dealing. It is the bifurcation for the convenience of the court and not for your convenience. What you have to do is that you have to be so thorough with the memorial as a whole. It is just that what this is a tactic, or this is a part of your activity which you have to do, but you should be aware of each and everything which is there, even what your co-motor is to be argue has to argue. So now what happens is you have basically put in what all things would be there. Then you start with your arguments. Now, while arguments, you don't have to read the entire memorial. No, you don't have to read your entire arguments at once. Nothing. What you have to do is you prepare a brief synopsis. Now, as far as that brief synopsis is concerned, what you have to do is, like, your brief synopsis should contain 2 to 3 liners of all those points which should cover the entire argument. Now, the entire argument would be placed before this court now, and it should be done in such a way that neither you have much questions from the court, or if you have any questions, that then you are able to steer through. So this is the way you have to go through your arguments at once. And the moment you are going with your arguments at once, you have to place reliance on the compendium which is there. And if you don't have a compendium, then in that case, what all the authorities that you have cited in your memorial, it is very important so that you show it to the judge that it is there and this is where I'm placing my reliance upon. See, it is very easy to argue because you have been going through this content for months now. Excuse me. But the point is that if the other person has to be convinced that this person is thorough with what the entire proposition is, you have to make that other person convinced that I am not arguing in air. What I'm arguing is backed by proper authorities, is backed by proper authors, is backed by proper case laws, which is duly there in our memorial also. So if your memorial has been well drafted, if it has been formatted properly, then it is very important for the judges. Like, it is important for you to make the judge peruse that particular thing, and that can be done only and only if you argue in the proper manner. Otherwise, your memorial would not be perused in the proper way. So it is the responsibility of the mooters that the way they argue. For example, if you are arguing a particular case, then you can say that your lordship, such and such thing happened. For this particular thing, my lord, your lordships may kindly peruse page number so and so of your memorial at paragraph number so and so. So now the judge is bound to open that page. If he has opened that page, he would come to that particular paragraph and he would say that, okay, here 2 to 3 cases are cited with the proper footnotes, which means that that there is a proper authority which is there. And after that authority, you have, that these arguments are just simply not in air. And at this point, if you have a compendium, then it would add to your advantage like anything. That the mooter is aware with the situation. He is so thorough with the arguments. Everything is clear in his mind. He has a complete seratum of what is there. And subsequently, this is backed by law, and they have the case laws with them as well. The case laws or the sections on which you are relying. So that makes, this is the finish of what we talk about. And this is something that gives you an added advantage over the other team. So this is how your arguments should be, and this is how your approach for your arguments should be. Next, like this is your arguments and this is something what you have done or at your own level. Now, one thing that comes at as an exemplary while you are arguing is the rebuttal part. You have argued, the opposite team would also argue. They would also try their level best to persuade the judges to allow their claim. So now what happens is it is your responsibility for the rebuttals. Now rebuttals is not simply that, like there were 6 to 7 points, you have noted down everything and then you're simply coming and you are giving response. No, there is a difference between replying and a rebuttal. Rebuttal is not a matter of right once one. So for example, if you think that okay something has been is left, we are saying you might be given a chance to rebut, you might not be given a chance to rebut. It is not a matter of right to every mover. But what you need to do is whenever the opposite side is arguing, it is the duty of the researcher. He has the main responsibility for it to simply jot down all the points which is being argued by the opposite side. And then they have to analyze that, okay, what were the important points, the strong points, and the weaker points. If they have any strong points which you think that, okay, like they would be able to simply sweep away, then you have to reply to that point. You just don't have to reply to each and everything what is being argued. No, that is not there. It would simply irritate because by this time you are already done with 20 to 30 minutes of your memorial exercise. No, even the judges are tired, even you are tired. No, not each and everything has to be argued at the time of rebuttal. But keep in mind, you have to be so smart that if something while you had which you like something which you had to argue and you could not, you have to put it in your rebuttals so that the point comes before the court again, because your facts has to be prepared with the court, and you have to argue and you have to plead each and everything which is there. So this is one thing how you have to prepare. You have to prepare. This is how you have to plead before the court, and you have to be so thorough with all your memorials, and you have to be on your toes. So I think with this, I would wrap up my arguments before you all. So I guess if there are any questions, then we will open the sessions for question answers.
Hello, sir. Good morning.
Yeah, good
Sir,
morning.
sir, when you say that the code bounds to open the page, when we say please see
Mm-hmm.
the page, see the page number. So
Mm-hmm.
it is compulsory to code the open the page, or it is on them that they will open or not open the page.
No, no, I'll tell you one thing. First of all, I didn't say that it is compulsory for the court. I just said that it would be so persuasive for you that you are able to convince the court to open that page. See, what happens is that whenever you are arguing, so at that particular point, it should appear that your arguments are backed by any particular authority or any case law, and these arguments are not in air. So while you are arguing, and you convey to the court that sir, this is that I request this honorable court to please open this page number so and so. And if you give an emphasis on that, then it generally happens that court do open that page. So it is not compulsory for them. It might happen that they'll put another question to you, but the point is that if they are able to open, there are high chances because otherwise they'll not open. But if they open that page at that point of time, they would see that all right, there is an authority which is there, and this would add to your advantage.
Okay, sir. Thank you.
Thank you.
Good morning, sir. Sir,
Morning.
actually, I want to ask this. As you said that the person needs to be submissive, but most of the time we have been told that argument must be in dominant and authoritative way.
See, I'll
So
tell
why?
you one thing. No, I'll tell you one thing. This is something which we were also told, but by like with time, this thing we understand. Just take an example. Law is something which we see in our day-to-day language. Have you been able to get something from the person who is in higher authority being arrogant? or
Yes, sir.
or you are able to get something when you are submissive.
Yes,
So
sir.
this is the only thing what goes in the moot courts also. It's like this was the opening thing which I said, because you are not there to simply argue. It is you are there to plead. If you have read CPC, then the words that are used are pleadings. Plead is something to plead. मांग रहा हूँ. You are not. It is not as a matter of right. You are going to the court and you are saying, I am pleading this. Please give me this relief. So you are seeking a relief. So you cannot seek anything being, very arrogant. If you are arrogant, you might get it. I'm not denying. You might get it. But being submissive, it would always be beneficial for you. And you should understand that where you are pleading, what is the, how's the bench and how is their approach. So in those cases, you have to assess, and that is how the things can be done.
Okay, sir. Thank you, sir.
Thank you.
Participants, if you have any questions, you are free to ask.
Have talked about compendium. So, sir, do we have to put whole case, that is facts and judgment, in compendium, or just the relevant thing which is relevant to our mood problem only?
See, if the judgment is not running into multiple pages, like if, for an example, if it ends in 30 to 40 pages, then I would advise that you have the whole case with you. Because what generally happens is that if you are placing just a single page, the judge would not understand that what is the authenticity of this particular page. At the max, what you can do is that, for example, if a page which is running into hundreds of pages, you can have initial 2 to 3 pages, and then you can simply put the page on which you are placing reliance. So that is one thing you can do. But for example, if a case which is there for 15, 16, or 20 pages or 30 pages, then it is advisable that you enclose the entire, the complete case law, and not just a single page, because single page has no sanctity. Then you would be grilled on that aspect, that why have you used only the single page.
Okay, sir. Thank you.
Thank you.
So, participants, you can ask the question either in the chat box, or you can unmute yourself and ask questions.
Sir,
Yeah, good morning.
so my question is, so if there's a memorial in the moot court competition, so what is the need of compendium? Because it is a waste of time, and also for framing and constructing the compendium, it takes lots of time. So what is the
Okay,
need of compendium?
okay, that's a really practical question, which is being asked. Like when you prepare any memorial, so you cannot give the entire case. All right, you just cannot reproduce the entire case law which is there. So now let me answer your question by putting another question. For example, you are just to a moot court competition. All right. So there are two sides there are two sides in front of you. One is simply relying on their own memorial and nothing else. They have a single spiral memorial with them. And on the other hand, there is a side which has 3 to 4 books with them. They have a complete, like, this much voluminous compendium with them, and they are very confident from their faces. So would you be a bit, a bit curious about, okay, what all do they have, to plead before this court? For the reason, the arguments that would come, it would appear that, okay, these arguments have been prepared after a lot of research, and there are, these motors have complete the authority to satisfy the court, that what all is there, is there any case law, or is there any commentary by different books, or if there is any case law or something. So after that, it becomes more authentic. There is the authenticity that is attached to your memorial. So it is because of that you are able to, like that is the finish that is there. So that is why it is always advisable that you prepare a compendium. It would be more like even you would be more confident while you are preparing a compendium.
Okay, okay. Thank you, sir.
Thank you.
So what we have to do for effective argument in moot court?
Effective arguments, like in what sense? Hello.
Participant, please be specific in your question. I request Vimal, can you repeat her question?
What we have to do for effective argument in moot court?
See, I would suggest you to first of all be so thorough with your memorial. Because if you are thorough with your memorial, then only your arguments would be effective. That is the first and foremost thing, which is, I guess, very obvious also. One. Secondly, for being effective, I guess the entire lecture was for effective arguments only. But I'll again give you 3 to 4 pointers. One, be very handy with the memorials that you have. Secondly, prepare a brief synopsis for what arguments you have to do. Two, third, be submissive in your approach. Submissive does not mean that you have to be, like you are beneath something, or your approach should be, just to seek the relief from the court. And fourth, just keep your senses open. Just be very very smart with what is being asked to you and how you have to answer the questions. So these are the points with which your arguments could be effective. Right?
Okay, sir.
Good morning, sir. Sir, if
Manu?
our arguments are not too good but our memorial is well prepared, then will it affect the results?
Yes, I would say it will. Because the point is that even if you are such a good person, but then also if you are with your relatives and you simply abuse your relative, so that won't make any difference. That even if you are such a good person, simply goes with your memorial also. If your memorial is too good, but then also if you are unable to portray to the judges, then it would give a bad impression. So your arguments have to be so strong that it would simply justify that what your memorial is all about. Because if your memorial is good, fine, you may get the best memorial award because that is a separate scrutiny. But to the public at large, nobody's there who can, who has the access to your memorial, and all you have to do is to justify that what you have done. So arguments and memorial are hand in hand. If your memorial is good, your arguments would automatically be good. And if your arguments are good, then your memorial would be considered as good automatically. So these things are hand in hand, and it is not, like you can simply rely on one thing. Both the things have to be uh, considered equally.
Thank you, sir.
Sir, what if our
Sorry, you're not audible.
Participant, you're not audible. Please try again.
Good morning, sir. I am
Hello,
Sophia
ma'am.
Raj from Bijnor. So, firstly, I would like to thank you for explaining all the points in a clear and understandable manner. Sir, my question is that what is the good way to seek prayer that we have high chances to get judgment in our favor?
See, first of all, the prayer is something which has to be, pleaded very properly while you
Okay,
are all right, and while you are praying, all the three members should stand one, Secondly, each and everything what you are praying is to be treated in a very proper and specific way. Because at the time of your drafting of memorial classes, you would have been taught that how to draft the prayer clause. Because prayer is something which is the the heart of your the memorial. That is the entire purpose of why you are there before this court. So if you have argued each and everything, every point properly, then the prayer is something when you are there, and like there are generally 4 to 5 prayer clauses. So if you are very less time constrained, you can simply like the initial paragraph of your prayer, which talks about in light of the points raised and authorities cited and arguments advanced, the council would like to plead before this honorable court, and then your 3 to 4 points, and for this act of kindness, and everything follows. So now the point is, if you have less time constraint, the most important prayer, which would cover the entire arguments, can be done one. Or if you have time, you simply your prayer should be like it should be by heart, and you simply go and narrate the entire prayer.
Okay, sir, got it. Thank you so much, sir.
Yeah, thank you.
Some one more question related to compendium. So in our compendium, can we put the case in our own language, or do we have to copy the case from Manupatra or some relevant sites?
See, you don't have to put the case in your own language, and you don't have to copy. The simple point is that you go to the website, and there is this option of printing, because there can be no tampering with any reported judgment at all. So what you simply do is you go to the website, you get it you get it printed, or you get it saved on the PDF and then get it printed. That's it. That is the only way which can be done, and not anything beyond that. Nothing has to be
So we
copied.
can't. So we can't write in our own language, which
No,
will
no, no,
be
not at all, not at all. To write judgment in your own language, you have to be a judge.
okay, sir. Thank you.
Sir, what if our research is not that good, but we are good in argumentation skills? Does that affect our results?
See, the fundamental to that is that you should prepare a team which has a perfect blend of everything. Your researcher should be too good at research, and your mooter should be too good at mooting. That is the perfect team. Because I understand that not one can do all the three tasks with perfection. So first of all, it is advisable that form your team in such a way that every aspect is covered properly. One. Secondly, even if your research is good, it has to be decent. There is no shortcut of any of any research. It has to be done, because your arguments would come out of your research only. If you think that you can simply go before the court, you have good argumentation skill, but the point is how. Okay, how you are arguing, and what is the content. So the content has to be there, and content comes from research. So if you are unable to research properly or something, so your arguments would automatically suffer. So if you yourself know that my research is average, or it is just above average, then you should try to form a team with the researcher, because at time all the researchers are also not good mooters. So it is very practical to form a team in such a manner.
Thank you so much, sir.
Thank you. Yeah, I guess Rainy has. Yeah,
So
please.
I have a question that what court manner we have to follow in rebuttal round.
See, for proper rebuttals, as far as court mannerism is concerned, the next session is on court mannerism and court etiquettes. So I would not be touching on that. However, what all contents you could do, and what arguments are there, for that, I would say, like to say something. First of all, whenever the opposite side is arguing, and I would say whenever your side is also arguing, the researcher should make notes that this is what we were supposed to argue, and this is what we have argued. So there would be a comparative analysis one that would help you in the other rounds also, and that would help in the rebuttals also one. Secondly, what the other part is arguing. For example, you are the applicant in this particular round, and you are making notes of the respondent. And if you end up being a respondent in the other round, so you would basically borrow the arguments from the other side if they were good. So first of all, it is very advisable to do that, to adopt good things. One. Secondly, if uh, if there is anything which has been argued by the opposite side which was not appropriate, or which I would not say appropriate, but if there is something which is not in their favor much, then what you can do is you can simply put that point, and if you are there in the rebuttal round and it is bang on, you can simply go and you can plead. You can have a bit overpitched tone, and you can just uh, try to argue that. So as far as rebuttals are concerned, you are pleading before this court, but you are basically negating the points of what the other has argued. So that tone can be a bit on the higher side as well, but you just don't have to deviate from what you have been arguing, and you don't have to go beyond of what your feelings are.
So, like, suppose what's the presentation or legal principle supports of argument, and how does it apply to the fact of the cases? If you suppose a case and which is not held in India, like, and this type of case like had in England, and how we can proceed like this type of case and the court judgment we can apply on this type of case like in India, which is going on.
See, the point is that in India there are a lot of authorities that we follow. We are common law system. All right. So still in contracts, and there are other laws also wherein till today we are following English laws. The decisions that were given by the Privy Council, the House of Lords, we are still following it. So there is nothing wrong, first of all, in following those judgments and citing those arguments. But if there are any, like for example, if your mood problem is on criminal law, then I don't think that foreign law would generally help you. But if it is on any international subject or any commercial subject, which does have international angle to it. For example, if your mood problem is on intellectual property rights, or if it is on human rights, then you can definitely use the foreign judgments also, the foreign authorities also. But it should not be that you have completely you just forgo Indian authorities on that. Try to find out Indian authorities first, because that has binding effect. If you have read laws of interpretation and administrative law, foreign laws can be persuasive, but it is not binding. So if you want to add an advantage to your arguments, you can very well rely, but try to have Indian authorities at the first place.
Good morning, sir.
Yeah, morning.
So my question is for rebuttal round, for on what points of the opposite team we have to focus on. Like I had query regarding the points on which we have to focus so that our rebuttals will become more effective or good.
See, your question is really good. I appreciate your question. See, first of all, you whatever you have argued, the entire thing has to be followed very closely. It starts with the jurisdiction, it starts with the facts, and it starts with the arguments. If, for example, you like the opposite side is arguing on the jurisdiction side, then the single liner, this court has jurisdiction, or what you have to reiterate what you have been pleading before this court. One. Secondly, the facts, if they have narrated, if they are there on the facts, and something is there which has been misstated, you have to be there on facts also. As far as arguments are concerned, arguments are one thing which has to be monitored very closely, because arguments is something on which you have to place reliance, and that is the entire this is the main point on which things can be rebutted, and that is precisely your case also. So I would say, if we rate it on a scale of 10, arguments is something I would say that you have to be there by like up to 6.
Sir, there's a question in the chat box by Neha Jasuja. It says, how much of an argument should be memorized in a moot court competition?
See, to have an insight and to memorize are two different things. It's not that you have to memorize anything, because, for example, if you have memorized something and you are stating something, and if a question or a single interruption comes in between, and you forget everything, then you have to start again. No, you have to have an insight of your memorial. You have to be so thorough. You don't have to think twice of what is happening. For example, if we ask you what is your name, you don't have to think twice that what is my name. You simply come and you simply tell us your name, your family background, and everything. But if you memorize something, then it will be very difficult for you to stand in a moot court competition, especially when the drilling round is there. So memorize. I would suggest, please don't memorize your memory. Be thorough with it.
Thank you, sir. So there's two more questions in the chat box. First is from Prashant Shekhawat that says, "Sir, how much does the time effective in marks and etc." And the second is by Dilpreet Kaur that says, "What are some common logical fallacies to watch out for in an argument?"
See, these are really good questions. First of all, for the Prashant, it says that how much does the time affect in the marks and etc. See, time is an important part. It is a competition at the end of the day. So, if you practice a lot, and while you are practicing a lot, you just know that okay, this is the time limit that I have, and after these time limit, this is if the questions are being asked, and this is what I have to plead. Even at the last, I would plead for another a minute or so. So time has, like, it is the essence of your whole argument. So you have to be so thorough, and you have to be so particular about the timing, and it does have a lot of effect, because if you are able to complete your arguments within time, you always have an added advantage. So time is important, and it cannot be just simply taken for granted. One. And common fallacies to watch out for in arguments is one thing. Like, it has to be taken as a whole. It's not something, any single, any particular thing. The point is that it all depends on case to case and facts and problems. So it is not a single particular thing that can be told at this hour. What you have to do is, you have to be there, you have to be on your toes, you have to understand, and you have to analyze from your arguments to what the arguments which are being taken by the other parties and what you are arguing. So it is for that you have to analyze and you have to determine. So that is how it should be taken.
Do we have any other questions, participants? Okay. Thank you so much, sir, for generously imparting your wisdom and enriching us with your valuable experience. It was a pleasure listening to you. I request all the participants to kindly turn on their camera for a group capture.
Thank you so much, everyone, for such a patient listening. And I hope that this helps you in
So
your
I have another
answer.
question.
Yeah,
As we know that as we're going to be lawyers, so like there's a plenty of independent things. So sometimes we can defend from the defendant side as well. Like, so as we know that the situation is like the defendant is the part of that like crime, and so how we can justify the situations like manipulate the like to plaintiff that he is a very wrongdoer and we are not, and we can win the chances of increase the winning the case.
see, it's a very, very vast question, because this includes experience of years. So, all right, I'll try to sum up to sum up my answer to that. The point is, first of all, being a lawyer or being an advocate is a responsibility. The responsibility to defend your client. That is one thing. And what you use the word manipulation, it is not manipulation. It is simply arguing your case. This is arguing your version before the court. There is a case, for example, let us take an example of a check bounce case. I hope you would have heard that thing, 138, generally we talk about. So there are a few essentials to that, right? Essential is that one person has taken a debt, After that date, what happens is that one repays the loan by way of a check, and this check is bounced. So these are the three essentials. So now it's not that you have to manipulate the court. The point is that even if you are on the side of the accused, you have to go before the court, you have to plead, and you have to satisfy the court that either of the essential is not met. All right. So the at max, what you can do is you can try your level best to plead before this to plead before the court, and then you have to leave to the court of whatever is happening. All right. So that is one thing you have to do. It's not manipulating court and like this is not how the things are. You have to simply plead your case to the best of the versions you have. And rest, I guess you learn over time.
Hello, sir. Sir, I have a question. Sir, I want to know whether can we cite definitions or any expressions in memorials?
Yes, absolutely, you can. And even if you are citing any definition or any codes or something, then it is always advisable that you give authorities of the same in the footnotes also, because definition, even I would advise that you should give definitions because it would make your memorial more authentic. You should definitely do that.
Thank you, sir.
Thank you so much, sir, for answering all the queries of our participants. It is always a pleasure to have you with us.
Thank you.
Now, I
Thank you
would
so much,
like
Tanya.
now I would like to invite Ms. Kanjan Sharma, ma'am, Assistant Professor, Rajasthan School of Law for Women, for delivering the vote of thanks.
Thank you. Good morning, all. I feel honored and privileged to get the opportunity to propose a vote of thanks of this session. Moot court workshops help the law students to learn the fundamentals and the advanced aspects of mooting. I assure that this workshop will provide you with all the information, knowledge, skills, and experience to participate and excel at various national international moot court competitions. Learning of argumentation skills being a core and one of the basic aspects of mooting has been dealt with thoroughly in this session. Now, I, on behalf of Rajasthan School of Law for Women, convey deep regards and hearty thanks to our esteemed guest speaker, Mr. Aditya Bohra, Latin Judiciary Mentor, Founder Director, Logical Education. Thank you so much, sir, for accepting our invitation and enlightening the participants with the knowledge.
Thank you so much.
Sir have guided extensively regarding appropriate and required argumentation skills that will be very beneficial for all the participants in preparing for moot court competitions. Thank you so much, sir, once again. Now, my special thanks to Principal Ma'am Dr. Vartika Arora for constant guidance in supporting shaping the session and the whole program. I'm very much thankful to Dr. Disha Bangarwa, co-convener, Ms. Palak Vashish, Secretary, and all the faculty members for their help and motivation. I'm very much thankful to the non-teaching staff who always stand by us. I would like to thank the moderator of this session, Ms. Tanya Roshan and Ms. Neha Jasuja, for moderating this session so greatly. I would also like to extend my deepest thanks to all the participants for joining this session and making it a successful one. Thank you all of you once again. Have a wonderful day.
Thank you. Thank you, ma'am.
Thank you so much, ma'am. Before ending this session, a reminder for all the participants to fill out the feedback form in order to receive a participation certificate of the workshop. Thank you all for joining. Hope to see you in the next session.
Thank you, Danya. Thank you, Kanjan ma'am. Thank you again, Aditya sir. It's always pleasure to listen to. I was listening entire this session, and this time we have twisted your session. Last time it was courtroom mannerism, and this time it was argumentation skill. And both session I have heard the last one as well. It was wonderful. And definitely, it's going to help the students in their future endeavors. Thank you so much.
Thank you. Thank you.
Thank you all the participants. Now you can leave this meeting. Thank you, everyone.
Thank you.